One of the questions almost every family asks me is this: can we just go ahead and empty the house before probate? Maybe a lease is ending, maybe everyone just wants closure. I understand the instinct, but in most California probate cases, the honest answer is no. Not yet, and not until someone actually has the legal authority to act for the estate. I'm Shanty Soerjono with eXp Realty. I work with families across California through probate and trust real estate. And this exact question, what to do with a parent's belongings, comes up almost every single week. Before we get into it, one important note. I'm a real estate specialist. I'm not an attorney, and I'm not a CPA. Everything here is general information to help you get your footing, not legal advice for your specific situation. For that, please talk with a licensed probate attorney. So let's start with the part that surprises people the most. When someone passes away without a will, what's called dying intestate, no family member automatically owns anything that person left behind. Not the furniture, not the jewelry, not the car in the driveway. Everything they owned, collectibles, artwork, electronics, clothing, firearms, vehicles, cash sitting in a drawer, coins, antiques, even the important documents, all of it becomes part of what's called the probate estate. And until the court actually appoints someone, a personal representative, sometimes called an administrator when there's no will, nobody has the legal authority to hand any of it out or take any of it home. So can family members just start dividing things up even if everybody agrees? Generally, no. I know that sounds strict, especially when it feels obviously fine within the family. But taking items early, before an administrator is appointed, is how good families end up in bad situations. It creates arguments about who got what. It opens the door to claims that something was taken or is missing. It makes the inventory the court requires much harder to complete accurately. And if you're the one who took the items, you could be held personally liable later, even with good intentions. The safest move, every time, is to leave everything exactly where it is until the estate is properly opened. Now, that doesn't mean you have to leave the house completely untouched. You can, and should, do what's needed to protect it. Throw out spoiled food, clean up, lock up valuables, board a broken window, stop a leak before it becomes real water damage. Keep the yard from turning into a neighborhood eyesore. Remove anything that's a safety hazard. All of that is protecting the estate, not distributing it. And that distinction matters a lot. What about the smaller things? Clothes, family photos, furniture, the stuff with more sentimental value than dollar value. I understand families want those items right away, but I'd still say wait until the personal representative has the authority to distribute them. Even something with almost no resale value can become the center of a real family dispute later. It's worth having it inventoried and handled properly instead of argued over. Here's another one people don't expect. A family member should not move into the house and start treating it as their own, even temporarily, without legal authority to do so. The personal representative has a fiduciary duty, a legal responsibility, to protect that property for every heir and beneficiary, not just whoever happens to have a key. Letting one person move in without authorization can create real legal and financial problems down the road. So what if the house needs to be sold? In most cases, it can't be sold until the court has appointed a personal representative, unless a different legal arrangement applies, like a living trust. Once someone is appointed, they can secure the home, keep the insurance active, arrange repairs, hire the professionals they need, and prepare the property for sale. And depending on the authority the court grants, often under something called the Independent Administration of Estates Act, they may be able to sell it without coming back to court for every single step. Now, if there's no will, California's intestate succession laws decide who inherits, and the court appoints an administrator who carries the exact same legal responsibilities an executor would have under a will. That administrator has to collect the estate's assets, prepare a full inventory and appraisal, notify both heirs and creditors, pay any valid debts and taxes, and only then distribute what's left according to California law. A few things skip probate entirely, and it's worth knowing what they are. Property held in a living trust. Property owned jointly with the right of survivorship. Payable on death or transfer on death accounts. And assets with a named beneficiary, like life insurance or most retirement accounts. Those pass directly to the person named. They were never part of the probate estate to begin with. So, practically, what should you actually do while you're waiting for the court to appoint someone? Here's the short list I give every family. Lock and secure the home. Keep the homeowner's insurance active. Don't let it lapse. Photograph every room and anything valuable. Don't give away furniture, jewelry, or collectibles. Don't sell a vehicle or any personal property. Keep the utilities on if the home needs them to stay protected. Write down a list of the valuable items you see. And save your receipts for anything you personally pay for to protect the property. The estate can often reimburse you later. Let me give you a real-world version of how this goes wrong. Say Maria passes away without a will. Her two children, with good intentions, start dividing up her jewelry, furniture, and collectibles right away. Nobody's been appointed yet. They just want to take care of things. Weeks later, a third heir comes forward and says some of those items were promised to them. Now, because nobody had legal authority when those items were divided, the administrator may have to try to recover them or figure out what they were worth after the fact, and that delays the whole probate and makes it more expensive for everyone involved. If those two children had simply secured the house and waited, everything could have been inventoried and distributed correctly the first time. So here's what I want you to remember. Personal belongings become part of the estate. They don't automatically belong to family. Don't empty the house or start distributing property before someone has legal authority. It's absolutely fine to secure, clean, and maintain the home in the meantime. Wait for the personal representative, the executor or administrator, before you distribute or sell anything. And good records, kept from day one, are what keep families out of disputes later. One more time, this video is general information, not legal, tax, or financial advice. I'm Shanty Soerjono, a licensed real estate agent with eXp Realty, not an attorney or a CPA. Please speak with the right licensed professional about your specific estate. But if you're an heir, an administrator, or just trying to figure out your very first step, I'd be glad to help. Reach out for a free, no-pressure probate consultation. I'm Shanty Soerjono with eXp Realty, and I'm here to make this easier for your family.